I haven't been anywhere to sign anything.
Your name is signed on this.
I'm not Rachel Ainley.
Stop talking over me. You did this, Miss Ainley. You signed this, Miss Ainley. You signed this. You did this.
Right out of the gate, tension sparks. One party swears they haven't signed anything, but the judge isn't buying it. This is where credibility will make or break the case.
Appearances are we have both parties appearing in person without counsel. We're set here today in this matter for a contempt hearing. We were here previously on November 8th, 2024, in which we had a little bit of a hearing, and the parties were instructed to bring all evidence and information for the court to present here today. At the last hearing, Ms. Ainley informed the court that she was prepared to proceed with an accepted offer of the house for November 22nd for tomorrow to sell the house. And she needed Mr. Ainley to sign off on everything. And that's why the court scheduled the final hearing for today. Mr. Ainley, this is your contempt hearing, and so you have the burden of proof. I'm going to have both parties stand, raise your right hands, be sworn in. Mr. Ainley, at the previous hearing, you had indicated that there was a list of property that you stated that you had left at the marital residence, and that either was just left there and you had not yet received, or that Ms. Ainley had destroyed and that you wanted compensation for, and you were going to inform the court of that property and of the value that you were seeking. You may begin with your testimony.
Yes, ma'am. After the divorce was final, we came to an agreement that day on everything that was supposed to be surrendered to me, and she agreed on that. Well, being that there was a restraining order or no contact order in place, I had to come to court and get a court date set. It was signed by on a Friday and on a Saturday and Sunday to go retrieve my property. And the agreement was she was not to be on the property or on the property when she was supposed to have everything staged in the driveway with all my personal property. And I went out that day, and some of the items were out in the driveway, and I pulled in and started getting stuff. Here she comes. She had her boyfriend or whatever, fiance, whatever, doesn't matter, but she was there, and I automatically just had an anxiety attack. So I just got what was in the driveway, left, and therefore I couldn't go back the next day because, I mean, she was there, and that was, that was a violation, really. I couldn't go back. She was there. And to my knowledge, she refused to let me go to the property while she is not there and not have access to anything that was in the home or my personal belongings or my four-wheelers and everything like that, and my pontoon, my chainsaw. I had I got a list here of stuff that was, and I did retrieve a few things, and what was there was damaged and beyond repair. I mean, it was destroyed. The holes drilled through the block of the four-wheeler, the lawnmower. I mean, everything I had was just what I got. We did retrieve that was in the driveway was totally destroyed.
Boom, the twist we've been waiting for. Allegations of forgery. If true, that's not just contempt, it's fraud, possibly a felony. The judge's tone sharpens. Watch closely. This next exchange might decide the entire case.
That she was not supposed to be there. She was, I mean, that was just a setup for me to go back to jail again for violating an order of protection.
At the hearing on September 28th, 2023, did you provide a list of that property to the commissioner or to the court of what you wanted to retrieve?
That list was already included with our divorce hearing. All of my personal tools, all of my personal property, the furniture in the basement.
First, Ms. Hess, formerly known as Ms. Ainley, were you at the property when Mr. Ainley went to retrieve his?
I was in the house, yes.
Why were you at the property?
I had nowhere to go, and I had to get his stuff out.
You were specifically told at the hearing with Commissioner Krupa on September 28th, 2023, that you were not to be anywhere on that physical property.
I didn't have a choice.
You did have a choice because Commissioner Krupa said not to be on that physical property, not to be on that residence at all.
I didn't have no idea what time he was supposed to even be coming.
It
Was I supposed to
says,
stay gone all day?
you
know.
did know, and I can tell you right now you did know because it says pickup times September 30th, 2023 between 2 p.m. and 4 p.m. and October 1st, 2023 between 2 p.m. and 4 p.m. So you knew exactly when he was going to be there. Exactly.
Leaving his stuff out there. He's
So-
already saying it was damaged.
You
I don't want.
just lied to the court. You just lied to
No,
the
I
court.
did not know.
You did know. You did know. That's
He didn't
physically.
show up. No, he did not show up when he was supposed to. There was time set in June for him to come. He didn't show. I didn't know if he was going to show or not. I wasn't going to take a chance of leaving his stuff sitting out there.
Mr. Ainley,
Your Honor, if it need be, I've got two witnesses that came with me with two trailers to load my personal property up. Her and her ex-fiance was out there. Her middle son Dylan was out there. They were all out there. She walked up and down the driveway following me, trying to talk to me. So that's all I got to say. She was there. She knew the date. She knew the time. I was there about 10 minutes after I think it was I really can't recall the exact time on the
Mr. Ainley,
clock.
I believe she knew the date. I believe she knew the time. She just lied to the court.
Yes,
I do
ma'am.
not find her credible at all.